5 seconds to go. Start. It is available to a public servant accused of the commission of an offence. The High Court has not adverted to this test, nor has it held that there existed a direct and reasonable connection between the official duty being discharged by the accused public servant and the acts committed by him. The High Court has, on the contrary, misdirected itself when it said that the accused had only committed an act of omission towards his official duties, which entitled him to the protection of Section 197 of the Code. It is difficult to appropriate what the High Court meant by saying that the acts of the accused were at best acts of omission towards official duty. It was not the case of the respondent before the High Court, nor is it his case before us that the complaint filed by Maya Devi disclosed any offence which could be taken cognizance of by him as an executive magistrate or investigated by the police. Assuming that the complainant and R.C. Chopra were living together even when they were not married to each other, the complaint regarding any such relationship could be filed only by the wife of R.C. Chopra or the husband of the complainant Urmila Devi. The complaint filed by Maya Devi could not provide a valid basis for the SDM, the Tehsildar, or the Deputy Superintendent of Police concerned to barge into the house of the complainant, humiliate or harass her, or drag her to the police station without the registration of any case or subject her to an uncalled for medical examination. The test of direct and reasonable connection between the official duty of the respondent subdivisional magistrate and the police officers concerned and the acts complained of thus fails in the present case, especially because there is not even a semblance of a lawful justification forthcoming from the respondent for what he did. Entering the house of a woman after sunset with a pose of police force, carrying video cameras, conducting an unwarranted search of the house, humiliating and invading the privacy of the complainant, insulting and humiliating R.C. Chopra by asking him to undress and dragging both of them to the police station for medical examination against their wishes, especially when male doctors were asked to examine the complainant, which added insult to injury, all remain unsupported by any lawful justification and have no connection with the duties that were cast upon the respondent as a public servant, even if a complaint alleging an adulterous relationship between the appellant and R.C. Chopra had been received by the SDM. The alleged acts of the respondent cannot therefore be said to be in discharge of his official duties or in the purported discharge of such duties. Public functionaries cannot, under the cloak of purported discharge of official duties, resort to harassment and humiliation of the citizens on the pretext of a complaint having been received by them, especially when the same does not disclose the commission of any offence triable by the executive magistrate or cognizable by the police, nor was there any other proceeding in connection with which such conduct could be justified in law. The plea of the respondent that the prosecution was barred under Section 197 CRPC has therefore to be rejected. In Rajiv Ranjan versus R. Vijay Kumar, reported in 2015 1 SCC 513, a complaint was filed against the appellant public officials for conspiracy to create false documents. This court had held that even while discharging official duties, if a public servant enters into a criminal conspiracy or indulges in criminal misconduct, such a misdemeanor must not be treated as an act in the discharge of his official duties in order to grant protection under Section 197 CRPC and elaborated as follows. The sanction, however, is necessary if the offence alleged against the public servant is committed by him while acting or purporting to act in the discharge of his official duties. In order to find out as to whether the alleged offence is committed while acting or purporting to act in the discharge of his official duty, the following yardstick is provided by this court in State of Maharashtra versus Buddhi Kota Subbarao 1993 3 SCC 339 in the following words. If on facts, therefore, it is prima facie found that the act or omission for which the accused was charged had reasonable connection with discharge of his duty, then it must be held to be official, to which applicability of Section 197 of the Code cannot be disputed. It is not every offence committed by a public servant that requires sanction for prosecution under Section 197(1) of the Criminal Procedure Code, nor even every act done by him while he is actually engaged in the performance of his official duties, but if the act complained of is directly concerned with his official duties, so that if questioned it could be claimed to have been done by virtue of the office, then sanction would be necessary. The real question, therefore, is whether the acts complained of in the present case were directly concerned with the official duties of the three public servants. As far as the offence of criminal conspiracy, punishable under Section 120B, read with Section 409 of the Penal Code, is concerned, and also Section 52 of the Prevention of Corruption Act are concerned, they cannot be said to be of the nature mentioned in Section 197 of the Code of Criminal Procedure. To put it shortly, it is no part of the duty of a public servant while discharging his official duties to enter into a criminal conspiracy or to indulge in criminal misconduct. Want of sanction under Section 197 of the Code of Criminal Procedure is therefore no bar. The question is, when the public servant is alleged to have committed the offence of fabrication of record or misappropriation of public fund, etc., can he be said to have acted in discharge of his official duties? It is not the official duty of the public servant to fabricate the false record and misappropriate the public funds, etc., in furtherance of or in the discharge of his official duties. The official capacity only enables him to fabricate the record or misappropriate the public fund, etc. It does not mean that it is integrally connected or inseparably interlinked with the crime committed in the course of same transaction as was believed by the learned judge. Under these circumstances, we are of the opinion that the view expressed by the High Court as well as by the trial court on the question of sanction is clearly illegal and cannot be sustained. The ratio of the aforesaid cases, which is clearly discernible, is that even while discharging his official duties, if a public servant enters into a criminal conspiracy or indulges in criminal misconduct, such misdemeanor on his part is not to be treated as an act in discharge of his official duties, and therefore provisions of Section 197 of the Code will not be attracted. In fact, the High Court has dismissed the petitions filed by the appellant precisely with these observations, namely, the allegations pertain to fabricating the false records which cannot be treated as part of the appellant's normal official duties. Stop.